PVL3702, Chapter 1. The nature and basis of contract. 1.1. The notion of contract. At the very outset, before we begin to discuss the law of contract, we must address the obvious questions. What exactly is a contract? How does it differ from any other agreement? 1.1.1. Contract as an agreement intended to create enforceable obligations. A contract is essentially an agreement between two or more parties, but not all agreements are contracts. Consider the following. A and B agree to play tennis together on Saturday afternoon. A married couple agree that the husband will wash the dishes after the evening meal. A and B pretend to agree as a joke on C. Or two actors sign a formal agreement on stage as part of a play. Quite clearly, none of these agreements could be enforced in a court of law as binding contracts. But why is this so? What makes these agreements differ from, say, an agreement in terms of which A sells a law book for B to B for 200 Rand? A moment's reflection will reveal that the parties to social and domestic agreements do not intend the agreement to give rise to legally binding obligations. And the same holds true for agreements entered into as a joke or as part of a play. The extra ingredient that distinguishes contracts from these non-binding agreements is this serious intention to create a legally enforceable obligation. Animus contrahendi. The absence of animus contrahendi explains why gentlemen's agreements are not enforceable as contracts. These agreements are intended by the parties to be binding on them in honor only, and not in law. So too, when parties sign a letter of intent, or note that an agreement is subject to contract, they are indicating that the agreement in question is not yet to be regarded as a legally binding contract. Whether or not the parties intended the agreement to be binding in law is a matter of fact to be determined on all the available evidence. In some cases, the issue might be a difficult one to determine, as when a father promises to buy his daughter a motor car should she pass her law examinations. As will be seen in due course, where a party lacks animus contrahendi, but leads the other party into the reasonable belief that he or she does seriously intend to bind him or herself, the law will protect that reasonable belief and uphold the contract, despite the absence of genuine agreement. 1.1.2. Legally binding agreements that are not contracts. On the other hand, the fact that the parties seriously intend the agreement to have binding legal effect does not necessarily mean that it is a contract. This is because not all binding agreements are contracts. Some agreements are intended not to create obligations, but to destroy them, or to honor an obligation by transferring rights. In this regard, the following classification of legally binding agreements is important, and a valuable tool for understanding the relationship between contracts and the law of property, including succession. First, we have obligationary agreements, whereby one or more obligations are created. Secondly, we have absolving agreements, whereby obligations are discharged or extinguished. And lastly, we have real or transfer agreements, whereby rights are transferred. Obligationary agreements are contracts such as sale and lease. A contract of sale, for example, obliges the seller S to transfer the thing sold to the purchaser P, who is bound to pay the price. An agreement between S and P to cancel the sale would be an example of an absolving agreement. Other examples would be an agreement by S to release P from her obligation, or the payment by P of the price, payment being a bilateral juristic act. S's obligation would be fulfilled by transferring the ownership of the thing sold to P. Such transfer would take place by traditio, which has both a physical element, the delivery of the thing, and a mental element, the concurring intentions on part of S and P to transfer and to acquire ownership, respectively. The animus transferendi and the animus acquirendi. This mental element of traditio is a real or transfer agreement, quite distinct from the obligationary agreement that is the underlying reason for the transfer, the causa traditionis. Another example of a real agreement is succession. Assume A has a right to claim money from B, arising from a contract or any other source of obligation. A might sell that right to C. The sale of the right is a contract, or obligationary agreement that obliges A to transfer the right to C. The sale itself does not transfer the right. That is achieved by succession, which in theory is a separate agreement entailing concurring intentions to transfer the right on A's part and to take transfer of it on C's part. 1.1.3 Legally binding agreements that are more than just contracts. Some legally binding agreements that create obligations for the parties cannot be regarded merely as contracts because they contain elements giving them another dimension altogether, or elevating them into a separate category. The most obvious example of such an agreement is marriage. Although it is based on the agreement of the parties and gives rise to obligations such as a reciprocal duty of support, marriage can hardly be treated like any other contract. Its primary purpose is not the creation of obligations, and many of the normal principles of the law of contracts do not apply to it. Thus, it cannot be made or unmade by the free exercise of the will of the parties without the intervention of the state, and it has certain invariable consequences that cannot be excluded by the parties. Marriage is accordingly best regarded as an agreement sui generis, giving rise to a relationship that confers on the parties a status of a public character. Another example is a judgment by consent. Parties to litigation frequently conclude an agreement settling some or all of the issues in dispute between them, and thereafter ask the court to give a judgment or to make an order that reflects the terms of their agreement. Such a judgment or order, if the court acquaintances, has dual character. On the one hand, it is clearly a judicial act, with all the authority, force and effect of any other judgment or order of the court. On the other, it remains in substance a contract of the parties, albeit one of an elevated status because of the superimposition of the command of the court. Agreements entered into with public bodies or organs of the state also present special difficulties because they straddle the divide between public and private law. The relationship between the state in its various manifestations and the person subject to it is generally one of superior versus subordinate. However, when the state enters the commercial domain and concludes contracts with its underlings, the playing fields are not to a large extent leveled, with the state generally, but not always, being treated in the same way as any other contracting party. Sometimes it enjoys more favorable treatment, for example, when a statute confers upon a minister or other public official a discretion that must be exercised in the public interest. Any contractual provision that seeks to fetter that discretion will not be enforced. At other times, the state is treated less favorably than the ordinary contracting parties, because its contractual rights must yield before its public duties under the Constitution of the Republic of South Africa 1996. This, while there is, as a rule, no obligation to give the party a hearing before exercising a contractual right to cancel an agreement, an administrative body or official might have to do so, by virtue of its public status. The principles of administrative justice frame the contractual relationship. It has been said that the Constitution requires that all administrative action must be lawful, reasonable, and procedurally fair. 1.1.4 The definition of contract. In light of the discussion above, a contract may be defined as an agreement entered into by two or more persons with the intention of creating a legal obligation or obligations. To this definition, one might perhaps wish to add a further element, namely that the agreement should be one that the law recognizes as being binding on the parties. This is because in order to be binding, various other requirements apart from the mere agreement must be satisfied. However, the label contract is in practice not reserved for agreements that succeed in creating binding obligations. Even if one or more of the requirements for validity are absent so that the contract fails, it is common practice to describe the agreement as an invalid contract. 1.2 Requirements for a valid contract. In order to be recognized as a valid and binding contract, the agreement must satisfy the following requirements, each of which will be considered at length in subsequent chapters. First, consensus. The minds of the parties must meet, or at least appear to meet, on all material aspects of their agreement. Secondly, capacity. The parties must have the necessary capacity to contract. Third, formalities, where the agreement is required, unusually to be in a certain form, for example, in writing and signed. These formalities must be observed. Fourth, legality. The agreement must be lawful, that is, not prohibited by statute or common law. Fifth, possibility. The obligations undertaken must be capable of performance when the agreement is entered into. And six, certainty. The agreement must have a definite or determinable content so that the obligations can be ascertained and enforced. Chapter 1, 1.3 The nature of contract. What are the characteristic features of a contract? First, a contract is a juristic act, that is, an act to which the law attaches the consequences intended by the parties. In this respect, it is like a will, and unlike a delict. However, whereas the execution of a will is always a unilateral juristic act, the conclusion of a contract is necessarily bilateral or even multilateral. There must be at least two parties to an agreement, and our law does not recognize a unilateral promise, policitatio, as binding, even where an agreement imposes obligations on only one of the parties. As with the contract of donation, a meeting of two minds is required. The donor's offer or promise to donate must be accepted by the donee. Secondly, a contract entails promises or undertakings on one or both sides. The undertaking may be to make a certain performance, immediately or at a future date. To give something, to do something, or to refrain from doing something. Alternatively, it may be an undertaking that a certain state of affairs exists, or has existed. For example, that the car is a 2004 model and that it has been serviced regularly. This is known as a warranty. Third, most contracts entail reciprocity in the sense that the one party's performance is promised in exchange for the other party's performance. For example, A will give B a sum of money in return for ownership of B's car. Hence the idea of contract as a bargain, which is so ingrained in some legal systems, such as English law, but not our own, that a promise will not be enforced unless it is supported by consideration, by which is meant that something of value must be given or promised in return, as a quid pro quo. This reciprocity highlights the economic function of contract as a medium of voluntary exchange of goods and services in the economy. Indeed, a contract forms the very basis of the free market system. The myriad transactions concluded by individual consumers and businesses at the microeconomic level shape the broad pattern of movements of goods and services at the macroeconomic level. This process of contracting is by and large an informal one, reflecting the general trend away from formality in modern law. Most people probably still think of contracts as documents drawn up by lawyers and signed by the parties in front of witnesses after a period of hard negotiation. This might be true of large commercial contracts, but it is hardly the norm. By far the majority of contracts today are concluded orally or even tacitly, without any formality whatsoever. Consider the following everyday transactions, all of which involve an element of contracting: buying groceries from a supermarket, boarding a bus or taxi, filling a car's tank with petrol, renting a movie, or parking a car in a public garage. Even notices on walls, for example, parking at owner's risk, or on the back of tickets and invoices can have contractual effect. The modern concept of contract is a generalized one. An agreement does not have to be of a specific type, such as sale, lease, or deposit, in order to qualify as a contract. This flows from the fact that there is freedom of contract, which means that parties can agree to anything that is possible and lawful. All contracts are consensual, in the sense of being based on an agreement of some sort, and are bona fide in that the parties are required to conduct the relationship in a manner consistent with good faith. Bona fide. Okay? These aspects of contract are discussed in greater detail where appropriate. Chapter 1, 1.4 Contract and the Law of Obligations. The law of contract forms part of private law, and more particularly the law of obligations. In this section, we are primarily concerned with the question: how does contract relate to other branches of the law of obligations? In particular, delict and enrichment. 1.4.1 The concept of obligation. An obligation is a legal bond, vinculum juris, between two or more persons, obliging the one, the debtor, to give, do, or refrain from doing something to or for the other, the creditor. As such, an obligation comprises a right and a corresponding duty. The right of the creditor to demand a performance by the debtor, and the duty of the debtor to make that performance. Pause for reflection. Each party to a contract is usually both debtor and creditor. Most contracts create not one, but many obligations, with each party being obliged to make a performance in return for the other party's counter-performance. It follows that a party to a contract can be, and usually is, both debtor and a creditor. The seller under a contract of sale, for example, is debtor in respect of the duty to deliver the thing sold, and creditor in respect of the duty to pay the price. This is because the labels debtor and creditor are used in relation to a particular obligation, rather than to a particular contract, which might create numerous obligations. End. The legal relationship created by an obligation is a personal one, binding only the parties to it. The creditor can demand performance only by the debtor. The debtor is obliged to perform only to the creditor. The right created by the obligation is therefore a personal right, a os in personam, as opposed to a real right, os in rem, such as the right of ownership, which lies directly in the thing owned and prevails against the world at large. Of course, there may be more than one party on either side, since a single obligation may exist between any number of co-debtors and co-creditors. If the obligation is enforceable by action in a court of law, as is usually the case, it is referred to as a civil obligation, to distinguish it from the less common natural obligation. Although a natural obligation is unenforceable, it does have certain legal consequences, unlike a merely moral obligation. For example, a debt owed under a natural obligation may be set off against another debt, and if the debt, though unenforceable, is nonetheless paid, it cannot be recovered in an enrichment action on the basis that it was not owed. Gambling debts are said to fall into this category. The primary sources of obligations are contract and delict. Other sources include unjustified enrichment, negotiarum gestio, which is unauthorized administration of another person's affairs, family relationships, wills, and statutes. 1.4.2 Contract and delict. A delict is wrongful and blameworthy conduct that causes harm to a person, for example, defamation or negligent damage to property. Such conduct obliges the wrongdoer to compensate the injured party. The essential difference between the contractual and delictual obligations is that the former are, as a general rule, voluntarily assumed by the parties themselves, whereas the latter are imposed by law, irrespective of the will of the parties. Within limits, contracting parties are free to determine the nature and content of the obligations that regulate their relationship. They do so by negotiating and agreeing upon the terms of their contract, that is, the provisions that set out the nature and details of the performances reciprocally owned by the parties. Any breach of those terms might entail legal consequences, including a duty to pay damages by way of compensation. That duty might flow indirectly from the will of the parties in concluding the argument or the agreement in the first place, but in reality is imposed by law as a consequence of the unlawful breach of the contract. There is accordingly a close similarity between a breach of contract and a delict. Both are civil wrongs, giving rise, in appropriate circumstances, to a duty to pay damages as compensation. Indeed, the same conduct might constitute both a delict and a breach of contract, as when a surgeon who has contracted to perform an operation negligently leaves a cotton swab inside a patient's body. In such cases, there is concurrent liability in contract and delict, and the plaintiff may sue on either basis. Traditionally, claims for damages in contract have been for financial losses suffered as a result of the breach, whereas claims in delict have been for injury to person or property. With the recent expansion of delictual liability into the field of pure economic loss, that boundary line has become blurred, and the potential overlap between contract and delict has correspondingly grown. However, the courts have shown great reluctance to permit claims in delict for economic losses caused by a breach of contract. This is a difficult topic that is best left until after completion of the courses in contract and delict. For present purposes, it suffices to say that a plaintiff who sues in delict must prove that all the elements of delictual liability are satisfied, including the wrongfulness of the conduct in question. The mere fact that the conduct constitutes a breach of contract does not necessarily mean that the conduct is wrongful for the purposes of imposing delictual liability. The conduct must infringe a right of the plaintiff that exists independently of the contract. For example, if A contracts with B to supply a machine capable of producing 5,000 bolts per hour, and the machine supplied produces only 3,000 bolts per hour, there is a breach of contract, but no delict, because B has no right independently of the contract to receive a machine that can produce 5,000 bolts per hour. But if the machine explodes and takes out B's eye, B may well have a claim in delict because the right not to be injured in one's person as a result of the negligence of another exists independently of any contract between the parties. 1.4.3 Contract and enrichment. Unjustified enrichment occurs when there is shift of wealth from one person's estate to another's without a good legal ground or cause for the shift. A's estate having increased at the expense of B, without a legally recognized cause, sine causa. A comes under a legal duty to make restitution, and B has a corresponding enrichment action, usually a condictio, to enforce the claim. Roman Dutch law recognizes a limited number of enrichment actions that were available in specific circumstances. The South African courts have extended these old actions in an ad hoc manner, but until recently have been reluctant to consider recognizing a general enrichment action, that is, one available whenever certain broad requirements are met. It is important to emphasize that the enrichment must be unjustified, in the technical legal sense of lacking a causa, rather than being unjust. If injustice were the criterion, any enrichment arising from a harsh or unreasonable contract would have to be returned, but that is not the law. Provided that it is valid, a contract is causa par excellence for any shift of wealth that flows from it. On the other hand, where a party transfers an asset to another in performance of a contract that is invalid for some reason, or that subsequently fails, the shift in wealth is sine causa, and one or other of the enrichment actions will lie, depending on the reason for the failure of the contract. Chapter 1, 1.5 Contract and the law of property. Property in the narrower sense denotes material things, corporals, such as a book, a car, or a farm, whereas the law of contract is concerned with interpersonal relationships arising from agreement, and hence with personal rights and duties. The law of things regulates the legal relationships between persons as legal subjects and corporal things as legal objects. As such, it is concerned primarily with real rights in things, ownership and lesser real rights such as servitudes and real securities, mortgage, pledge, or hypothec. In a broader sense, property denotes anything with monetary value that is capable of forming an asset in a person's estate. In this sense, property is not restricted to corporal things, but includes also immaterial property, such as copyright, patents, and trademarks, and personal rights, whether arising from contract, delict, or any other source of obligations. Much personal wealth today is made up of bundles of personal rights. For example, shares in a company, insurance and endowment policies, beneficial interests in a trust, and pension rights. Any commercial transactions Many commercial transactions involve both the law of obligations and the law of property. That is to say, they have obligationary or contractual and proprietary aspects. The sale of a house, for example, entails both an agreement to give transfer of the property against payment of the price, the contract of sale, and the actual transfer that occurs when the agreement is implemented by registration of change of ownership. So too, in a donation, the donor's promise to donate is implemented or executed when the donor honors his or her promise by handing over the gift. In the context of cessation, as has been seen, it is common to distinguish between the obligationary agreement creating the duty to cede the right in question and the real agreement of cessation whereby the right is actually transferred. In the examples just mentioned, the contract is the underlying reason or causa for the transfer of ownership that follows. If the contract happens to be invalid, there is no just cause, justa causa, for the transfer. Ownership will nonetheless pass because South African law adheres to the abstract rather than the casual system of transfer. However, since ownership has passed without a proper cause, the transferor will generally have an enrichment action to recover the property. This being merely a personal action, the transferor is at risk. If the transferee goes insolvent before the property is returned, the transferor will not be able to get the property back and will have only a concurrent claim against the insolvent estate. When an estate is insolvent, there are insufficient assets in the estate to meet the claims of all the creditors. After the secured and preferent creditors have been paid, the balance of the estate, if any, is equally shared among the concurrent unsecured creditors. The transferor might thus receive only a fraction of the value of the property. This illustrates the importance of the distinction between real and personal rights. Had ownership not passed, the transferor would have been able to recover the property from the insolvent estate with a vindicatory action. Re vindicatio. Chapter 1 1.6 The development of the modern notion of contract. Our law of contract is essentially a modernized version of the Roman Dutch law of contract, though the common law principles are today supplemented by a number of important statutes, foremost of which is the Consumer Protection Act. And like all branches of the law, it is of course subject to the Constitution, the fundamental bedrock or grundnorm from which all law in South Africa now derives its validity. No rule, no principle, and no doctrine of contract law can survive unless it is consistent with the Bill of Rights and the normative framework of the Constitution. The courts are therefore empowered and enjoined to ensure such consistency by developing the common law where necessary, and when developing the common law, they must promote the spirit, purport, and objects of the Bill of Rights. It follows that no rule or principle of the common law of contract should be considered sacrosanct, no matter how deeply entrenched or how impressive its pedigree. That said, it should not be assumed too readily that those rules and principles molded over centuries by jurists not wholly oblivious to the demands of equity, are necessarily deficient when measured against the standards of the Constitution. Whatever changes may come in the future, it certainly remains true today that despite some significant legislative changes and a great many more judicial adaptations or innovations, including a fair amount of borrowing from English law, the fundamental principles of our law of contract are those expounded by the Dutch institutional writers. And although those same principles have their roots in Roman law, the modern notion of contract differs fundamentally from the Roman one. To understand the foundations of the modern law of contract, including statements often encountered, such as that today all contracts are consensual and bona fide, we need to be aware of the historical background of our system, and more particularly of the generalization of the notion of contract that took place in the 17th to 18th centuries. We need to appreciate the significance of the acceptance of the principle, pacta sunt servanda. Agreements must be honored. 1.6.1 Roman law. When considering the Roman law, we must remember that we are dealing with centuries of legal development, progressing from the strict formality of the early stricti juris contracts to the sophisticated informality of the later consensual contracts based on good faith. Roman law had a law of contracts rather than of contract. It never developed a fully generalized theory of contract. That is, one that regards any agreement meeting certain general requirements as an enforceable contract. Instead, it recognized a number of distinct categories of contract. First, real contracts, created by agreement plus the delivery of the thing in question. Secondly, verbal contracts, of which the most important was stipulatio, created by the use of prescribed formal words to express a promise. Third, literal contracts, created by recording an agreed debt in a ledger. And fourth, consensual contracts, created by mere agreement. No agreement that fell outside these defined categories was a contract, no matter how seriously it was intended by the parties, because the fundamental principle was ex nihilo pacto nor oritur actio, which means informal agreements or bare pacts give rise to no action. This only in the case of the consensual contracts, sale, lease, partnership, and mandate, was mere agreement sufficient in itself to create the contract. All the other contracts required some further element. It may be that this additional element is the causa that some texts say is required for a valid contract, but the meaning of causa remains obscure. Roman contracts were further classified as being either stricti juris or bona fide. The earlier unilateral contracts were stricti juris, characterized by a strict and rigid formalism, while the latter bilateral contracts, including all consensual contracts, were bona fide. Disputes arising out of them had to be settled by the judge in accordance with the flexible principle of good faith. The development of consensual contracts was prompted by the commercial needs of the growing Roman state, as formalism impedes trade and commerce. The trend towards informality and generalization of the notion of contract continued in later centuries. First, with the recognition of the so-called innominate contracts, then with the enforcement of certain informal pacts, either as independent agreements or as additional terms modifying the consequences of one of the recognized contracts. And finally, the most important of all, the relaxation of the formal rules with regards to stipulations. The general view, however, is that Roman law never quite reached the stage of enforcing all serious and deliberate agreements as contracts. 1.6.2 Roman Dutch Law. The Roman Dutch writers completed the process of generalization, influenced, it would seem, by canon law, by the body of medieval commercial law known as the law merchant, and by Germanic customs. They discarded the subtle distinctions of Roman law of contracts and accepted as the basis of the Roman Dutch law of contract the fundamental principle that, as a matter of good faith, all serious agreements ought to be enforced. All contracts were now said to be consensual and bona fide, that is, based on mere agreement and good faith. Strangely, however, many of the writers continued to assert that a justa causa, or rechtelijke oorsaak, was a necessary element of contract, without defining that elusive concept. This uncertainty gave rise to a celebrated dispute in early South African law. 1.6.3 Causa and consideration, a celebrated dispute. In the late 19th century, the Cape Supreme Court, under the dominating influence of Lord Henry de Villiers, adopted the view that by justa causa was meant valuable consideration, in the English legal sense of a quid pro quo. In other words, even a serious promise should not be enforced as a contract unless the party gave or promised something in return. This interpretation of justa causa met with fierce resistance from learned jurists in the North. It was challenged as historically incorrect by the eminent Mr. Justice Kotze in his annotated translation of one of the great books on the Roman Dutch law, and was later rejected outright by the Transvaal Supreme Court under Unisa in Rood versus Wallach. Lord de Villiers refused to back down, however, and so the dispute rumbled on until it was finally settled, nearly 50 years after it started, by the appellate division in the famous case of Conradi versus Rousseau. The court ruled that the English doctrine of consideration forms no part of our law. In South Africa, any serious and deliberate agreement made with the intention of creating a legal obligation is a binding contract, provided only that the agreement is lawful and possible of performance, and that the parties have the requisite capacity to contract. Unfortunately, although all members of the court agreed that causa did not mean consideration, they could not reach agreement on what it did mean. The dominant view was that it meant the ground or reason of the contract, that which brought it about. But another view was that it meant the particular transaction out of which the obligation is said to arise, be it sale, hire, donation, or any other contract or handeling. Subsequently, however, justa causa came to be treated both by the courts and by academic writers as meaning no more than that the party should have a serious intention to create a binding contract, and that the agreement should be a lawful one. As such, the concept of justa causa is entirely redundant, for it merely repeats other requirements for a valid contract. Regrettably, in Sambo Nasionale Bouvereniging versus Friedman, Janssen questioned this tendency to allow justa causa to be absorbed into the requirements of legality and animus contrahendi, and the concept was unnecessarily employed to deny liability in a subsequent case. Perhaps, therefore, the last word has yet to be spoken on the meaning of justa causa in the modern law of contract. However, the overwhelming weight of academic opinion is that the concept has become redundant and should be allowed to die a natural death.